Hello, this is Erick Widman from Passage Immigration Law. We've got another action-packed lineup of great questions and answers for you. Very happy that you're tuning in, and I'm glad that you keep submitting such great questions. We have several really good questions about being a student in the US and the types of visas that are available. So the first question is, if I want to study in the United States, what types of visas would suit me? So the two main types of visas that you'd want to consider are the F1, F as in Frank, and the J1 visas. F1 academic student visa allows you to come here for a full-time load of studies, and you're going to have to take several important steps to get yourself approved before you leave, but it is overall the most common type of student visa option available. So the first big step is to get admitted to a school and find a school that's the right program for you, whether it's undergraduate, whether it's English training, or it's graduate school. And you're going to want to get admitted to that school and have them issue Form I-20 that you're going to use as proof that you've been admitted when you go to apply for your F1 student visa. So you're gonna have to hand over and submit the I-20 form along with submitting your DS-160 non-immigrant visa application form. So there's a lot of paperwork to do, but the hard part, probably the hardest part, is coming up with the money to fund the expensive F1 student visa. But it is known to be an excellent investment because you can partake in optional practical training, OPT, for a year. Oftentimes people get hired on to be a H-1B full-time worker after that. You're able many times to do CPT, curricular practical training, and work before your degree is finished. So there are some solid options available that make it worthwhile to do the F1. The J1 visa, exchange visitor visa, is originally intended to help promote cultural exchange, and a sponsor institution is involved. And so there are some variations, slight variations with the J1 and the F1. But you have to, instead of an I-20, get a DS 2019 form when you go to apply for your J1 visa. So sponsor institution has to be involved, and you have to secure funding for at least part of your J1 student status. And there's a variety of great options available. Definitely look online with the Department of State website. Keep in mind that the J1 visa, a common downside to it is that you might have a home residency requirement, known as the 212E residency requirement, that requires many people who've received funding from the US government or your home country to go back and live in your home country for 2 years, be a resident there, and then basically show how you've earned the investment into your special education and the funding. So that oftentimes slows down your momentum over here in the land of opportunity, where the economy is so big and the opportunities are huge. So watch out for that. Not all programs in the J1 realm have the 2-year residency. Okay, next question. I have DACA from Obama, and I want to know if there's any law for the dreamers to get legalized. DACA, it has been a frustrating, really huge roller coaster for so many dreamers, so many kids who were brought here when they were young and don't have any knowledge of the country they were born in, but are in limbo because of our messed up immigration system. So it is really frustrating that you've been subject to political ping pong and being bounced around through the court system, and the latest set of litigation, current status here, summer 2022, the courts are basically in the process of making some decisions, doing hearings, Texas and New York. The status quo right now is that you can renew your DACA. You can't apply for the first time. So to you who asked the question, if you already have DACA, sounds like you did, you're hoping to get legalized and get a green card or citizenship, that's currently unlikely for a while. When Biden first came in, there was a brief window of opportunity where we were all hoping there could be some real progress made, but that fizzled out. That was frustrating. So right now you can renew your DACA, your work authorization, and definitely do that. That is something you can proceed forward with USCIS. If you don't have DACA yet, then you cannot file for the first time. Here's the thing. You can, in fact, file, but it's going to be held in limbo. It's not going to be approved or rejected. USCIS will take your filing fee. It'll be accepted, receipted. You'll get your receipt notice. And for some people, that could be a reasonably good decision, because an argument can be made that if you're in line, if USCIS already has your application, then maybe the latest court decision or executive order could give priority to those who have a pending application. But it also depends on your unique circumstances, how strong of an applicant you are, whether you have any criminal history. There's a variety of factors that you want to take into account if you decide to go forward with a new application. But in general, it's not going to get you an approval anytime soon. You can only refile and renew. All right. Now, here's a fiancé visa question. I already have my fiancé visa, my K-1 visa, and I'll get married to my fiancé in a few months. I would like to seek assistance getting myself permanent residence status after my wedding. So you have to apply for a green card. You've got to adjust status after you get married. So your current status is K-1 fiancé visa holder, but you want to become an adjustment of status applicant, and that's the only way forward to long-term status and a green card. So you're on the right track. So you're going to have to file Form 485, adjustment of status. You don't have to file Form I-130 because your fiancé already filed a different petition for you, the fiancé visa petition. So you've got to apply for work authorization, advanced parole, an affidavit of support from your new spouse will have to be provided. So all those forms will have to be submitted along with proof of your marriage and your marriage certificate. You can certainly do this with help of a good law firm. Feel free to get in touch. Of course, many people do it on their own and then come and seek help from an attorney if something gets stuck or if there's a problem. We'd be happy to help. Those are the main forms you need to deal with that you have to submit. And you're going to want to provide a lot of good supporting evidence to show your genuine marriage. That obligation continues on. You're also going to want to double check if you need to submit your medical application. If you're still within a year of when it was last held, you should not be required to do another medical. But there's some complexities to that rule. So get in touch with us or look online, get the right answer but in general, a year is a benchmark to look for whether you need a new medical or not. Next question. My parents are green card holders for 11 years, and I'm looking into their naturalization. Before moving forward, can you share what are things to consider about getting naturalized? So congratulations to your parents. That's great that they are eligible. And as a threshold matter, that's of course what you want to make sure. Is the foundation solid for how they got their green card? Was there anything complex or questionable or challenging about getting their first green card? Was there any misrepresentation? Since they've had their green card, they're going to want to look carefully. You can help them do this to make sure that there aren't any additional reasons they could be inadmissible to the US. That is still a factor. whether it's a criminal issue, whether it is some kind of immigration violation that they've committed. And you're going to want to make sure that they're fine paying U.S. taxes for the long term. As green card holders, the tax rules are essentially the same as citizens, but it's certainly a big permanent step to take when you naturalize, because you're pledging allegiance to the U.S. forever, and you're also going to be paying taxes forever. There are tax treaties out there, but even if you live abroad, tax issues are a factor. And finally, as parents, they're able, in many cases, to benefit from exemptions to the citizenship exam, the civics test, or the English test. And there's a couple different rules out there. Got one of them right here. Yes, age 50 or older at the time of filing for naturalization, and you've lived in the U.S., if your parents have 20 years in the U.S., that's a 50-20 exception. I don't think your parents qualify. There's also a 55/15 exception where they're exempt from the language requirement, but they still have to take the civics test. So thank you so much for getting back in touch. Thank you for listening and asking great questions. Feel free to follow up with these questions. Contact us at Passage Immigration Law. We look forward to hearing from you, and take care.